We've spent a bit of time looking at what law is and the elements of the Australian legal system. Why don't we look at how the major parts fit together, how it actually works in the case of Australia in particular, and we're going to look specifically at Queensland for some of the elements so that we get an idea about how two governments actually work together. Now, you may remember that in one of the early videos, we highlighted how good law needs to be flexible. So that means a good legal system will allow for change. There are many reasons for change. There could be problems with the current system, community expectations can change, there could be lobbyists looking for change, or indeed there can be changing technology. So there's lots of forces in play that lead to the need for change. And under our common law system, there are two ways that change can occur. The first is that the relevant parliament, the parliament with the power to make law in an area, can pass an act or a statute that creates a new law. The second way that it can occur is when a court in a relevant hierarchy makes a judicial decision that is binding on lower courts through the doctrine of precedent. We'll get to that in a little bit. So in certain instances, judges can make law via the decisions that they make. And for instance, the Mabo decision about Indigenous land rights is an example of that. So where do these ideas for a new law actually come from? Well, they can come from many sources. There could be specific lobby groups who are interested in having their ideas turned into law. A government can be elected with a specific policy about a change in law. Courts can propose new laws through the doctrine of precedent. There's often calls for changes through the media, through law reform bodies, and indeed public servants often spend a lot of their time thinking about how to make our law better. So there's lots of ways that a proposal for a new law can arise. Okay, so we've got this proposal. How do we transform that into a law? Well, we do have to think about how the legislature actually operates. We have federation, which means that we have a federal parliament and the state and territory parliaments. So in the case of Queensland, you have the federal and then you have the Queensland Parliament. Now, in the federal parliament, it's a bicameral parliament, which means that there's a lower house, which is the House of Representatives, and there's the Senate. In Queensland, it's very unusual that we're the only state or territory that is unicameral. There's only one house, the lower house, and that's the Legislative Assembly. Now, in the other states, they have an upper house, which is called the Legislative Council, but not in Queensland. The other key position that we need to recognise is that of the head of state. Now, you remember that we're a constitutional monarchy, so that means any law has to get what we call royal assent. So the King of Australia actually has to approve and turn it into law. That's legally how an bill turns into an act, how a proposal becomes law when the Crown approves it, when it gets royal assent. Now, of course, it's not actually the King, it's their representative. So federally, it's the Governor-General, and at a state level, it's the Governor of Queensland in our case. So we have these three bodies that are involved in the production of a new statute. The House of Representatives, the lower house, the Senate, and the Governor-General at a federal level. At the state level, we only have two. We have the Legislative Assembly, the equivalent of the lower house, although there is only one house here, and the Governor, which is the equivalent position of the Governor-General. So why two houses? Well, one of the things about the Westminster system is it likes to have a check and balance, not give all the power to one group. Historically over in England, this happened when power transferred from nobility to the average citizen. So they have the House of Lords, which the nobles were in, and the House of Commons, which was where everyone got a vote. And over time, there's been a shift in power. But the original idea was you had to get both these groups to agree to a new law. That was the only way that we could get a relatively benign shift of power out of this elite group into the general population. Australia's a little bit different. We have two houses, the House of Representatives and the Senate, and their structure goes back to some ideas that we talked about earlier, federation and being a liberal democracy. So the lower house, or the House of Representatives, is where we see best this idea of liberal democracy, where roughly one vote, one value in Australia. So when you get a certain number of people together, approximately the same number of people, they get to elect a member into the House of Representatives and send someone along to Parliament who can actually make the laws. So why the second house? Interestingly, one of the problems that the founders of the nation were trying to solve when they came together was the fact that some states were afraid that other states would take advantage of them. So, for instance, Queensland and Western Australia, with relatively low populations, were worried that, say, Victoria and New South Wales would have more members elected to Parliament, and therefore they would only make laws that were good for New South Wales and Victoria and not good for Queensland and Western Australia. So the states were worried about this particular problem. And the way they solved it was by putting a second house, the Senate. That's why the Senate is sometimes called the States House. Now, the difference in the Senate is that it's not one vote, one value based upon population. The principle there is that each state gets the same number of senators. So there are 12 senators from each state. And as a result, if you have a bill or a proposal for a law that's going to turn into an act or a law, it has to get enough votes in both houses. So it has to pass, for want of a better term, the majority, those elected by the majority on a one vote, one value. But you also have to have, for want of a better term, a majority of states agree, enough senators from different states, so that you couldn't just get two states with a huge population outvoting the rest of the nation. So really, it's a check and balance, and to make sure that all of the laws being put in place are for the good of the nation and not just a select number of states. So how does a bill or one of these proposals become law? It's got to go through a lot of stages, a lot of review to make sure people understand it, and hopefully that's as good a law as what we can come up with. So we have the idea and it gets drafted into the form it's going to be as a law, which, as I've said a number of times, is called a bill. So a bill is a proposed law. Okay, it's not a law yet. That bill then comes into Parliament. They call it introducing it into Parliament. Now, technically, it can either go into the upper or lower house, but most actually start in the lower house. So you can see here we have this proposal. They draft it into a bill, and that bill goes into one of the houses, generally the lower house. Now, the process within the House is that there are a number of readings. A first, a second, and a third reading. The reason is there has to be a chance for those politicians to read and review and discuss that particular proposed law. It's a check and balance to make sure people have enough time and resources to do it. Sometimes it might get set off for a special investigation, so it goes to a committee. But by the time of the third reading, we actually get a vote. And if a majority agree and it gets passed, it goes into the upper house where it goes through a similar process. If it gets agreed at in the upper house, it will finally go through to, if it's the federal parliament here, the Governor-General, who will provide royal assent. They will sign the bill into action. And of course, by convention, the Governor-General acts on the advice of the Prime Minister, who has overseen the passing of this, so they will sign what the two houses approve. When they sign it, it will have a commencement date, which is when it will begin, and on that date, that comes into force as a law. I'll leave you to look over the process in Queensland. It's quite similar, only we only have one house, so it looks a lot simpler. But we do have that same process of multiple readings within the House and even some investigations by specific committees to try and ensure that there's a check and balance and that people actually know what they're voting on and have a chance to object and discuss all of the aspects of that legislation. So while we've said that the legislature is the arm of government that makes the law, because of the Westminster system and the way we operate, when we're talking about making law, we do have to understand a little bit about the executive. So why don't we look at some of that detail now? So the executive is the arm of government that is charged with administering the law, which just means carrying on the business of government within Australia. According to the Constitution, the executive power of the Commonwealth is vested in the King and exercisable by the Governor-General as the King's representative. Oh my goodness. So we see the King and the Governor-General coming into it. But really, the Governor-General acts on the advice of what's called the Federal Executive Council. That's all the Commonwealth ministers. So in essence, the Governor-General always does what the Prime Minister recommends. There have been a couple of very rare exceptions that we won't go into when there was a log jam around power at the top, and that's why we have the position. But in general, and by convention, the Governor-General does what the Prime Minister recommends, because the Prime Minister is there leading the Federal Executive Council. So how does this really work? Well, a political party, generally we'd talk about the Labor Party or the Coalition in Australia, so the Liberal and National Party. So a political party is elected to power, and they get elected to power. They get power when they have a majority of seats in the lower house, the House of Representatives. So whoever has the most seats, and specifically a majority, is said to hold the confidence of the Parliament. So they get to choose who's in charge of the various departments. They choose ministers who are responsible for particular areas of government or portfolios. For instance, you'll put a minister in charge of immigration. So they're in charge of that topic as well as the immigration department, because the immigration department is the executive charged with implementing that policy. Now, some of these topics or areas are more important than others. The important portfolios, for instance, issues like defence and treasury federally, are called senior ministers. Less important portfolios are called junior ministers. And a minister, or someone who's in charge of a department, can come from either the House of Representatives or the Senate. Okay? You don't have to come from one of the house. You can come from either house to be in charge of one of these portfolios. Now, the rest of the members of that political party who makes up government, the rest of the majority, they don't get a ministerial portfolios, and they're called backbenchers because they sit on the benches at the back with the ministers in the front during Parliament. Now, in reality, on a day-to-day basis, there are too many people in this Federal Executive Council for effective, quick decision-making. So most of the power is exercised by a subset of the Executive Council called Cabinet, a key body in understanding Australia's legal system. Cabinet are the most senior ministers and the Prime Minister, and they will be making the recommendations to the Governor-General. Now, because our system is adversarial, what we then have is a second group, the political party who comes second, the next to largest number of seats, who are called the opposition. And then the leader of the opposition, so we don't call them like the shadow prime minister, they're called the leader of the opposition. They appoint shadow ministers, people who pretend to be the minister or concentrate on critiquing the minister in the government. And they also have a shadow cabinet to try and formulate policies and ideas to differentiate that party and compete with the party in power. Okay, so you've talked about the executive, but what the hell does that have to do with making law? Well, often what happens is Parliament will pass legislation with the overarching principles and objectives, the thing they're trying to regulate, but they will then delegate the detail to the executive branch. They need to do that because in Parliament, they don't really have the knowledge or the time to articulate the fine details. And not only that, you might want to change the details from time to time as circumstances changes. For instance, if you tried to regulate some technology, you'd need to be updating those regulations. So you don't want to have to go to Parliament and get it through this long-winded process again. So you end up with these two pieces of law that fit together. One, the overarching principle, etc., which must be made by Parliament, and then the articulation of the law in operation, often called regulations or bylaws or orders in council. So this, for instance, is how councils operate. There aren't three sources of government power in Australia. Councils get their power from the state government. They're delegated the power to make laws about things like parking and sewerage, all detailed things. And in the same way, government departments, say the Department of Transport, can make rules around, penalty regimes associated with speeding, licensing requirements, etc. Those detail things. So, for instance, the Parliament says you've got to have a licence, and then the details around what you've got to do to get a licence can get delegated to the government department, who knows a lot more about those details. So this delegated legislation has the same effect. It is a law. It has the same effect as an act of Parliament. That's because the delegation of the power has come from an act. So there's an accountability mechanism back up through the act. So for a practical perspective, this is how QUT can make parking laws. Have you ever thought about that? If you're at home, you can't fine people for parking on your property. You don't have the right to fine people for parking. But QUT can. QUT can. How can it do that? Well, that's because there's a QUT Act that was made by Parliament. And in the QUT Act, it allows QUT to actually make the road rules on campus. These road rules, like parking fines, are a form of delegated legislation. They are subordinate to the QUT Act. The only way that these are laws is because the QUT Act allows them to be laws. And as we've said, Parliament does that for a number of reasons. Often they don't have the time to debate upon every rule and regulation. It's a time-consuming process and they can't do that for all of the detail. Often they won't have the knowledge. The rules and regulations can be complex and very technical in certain areas, and they're often not best made by politicians. They're often best made by experts in the area. And in many other cases, the government department or local authority are actually closer to the problem and know best how to solve it through the detail of the regulations. Now, having said that, there's a number of problems with delegated legislation. Many people would argue that it's undemocratic. With our liberal democracy, laws are supposed to be made by elected representatives, and these aren't. They're made in a way that isn't open to public scrutiny. So we really have unelected officials making these rules. The second major problem is regulatory burden or over-regulation, right? You allow people to make laws, and they will. They'll make a whole hell of a lot of them, many more than what you would actually probably want. So there are two key problems with delegated legislation, despite those advantages in using this approach. And if you're interested in how it works, here's an example. The reason I chose this example and maintain this specific example, even though it's getting a little bit older, is I think most people are aware of the problem of smoking, the idea of Parliament saying, well, we want less people to smoke, so we're going to implement plain packaging of tobacco. So they do that in the Act and the piece of legislation. The problem becomes, what is plain packaging? You have to define it. So that's where a lot of the regulations come. They actually specify things like what colour glue, can the cigarette pack smell, can it play music, how big is the cigarette packet, how many cigarettes can it, like the detail in it is enormous. And it gives you a sense of why you would delegate the regulations to another body, hold the principles of making things plain packaged, and then delegate the details to another body. So it's a great example that you can actually look up to see how the two fit together and why you might do it. So that's a breakneck review of how we turn an idea for a law into a piece of legislation, one of the forms of law in Australia, or one of the sources of law within Australia. Next, we're going to look at the second source of law, judge-made law. How does that come to be in the Australian common law system?